talk, which is Gaza, a legal analysis and response.
Why did you sign before
you
said that?
It's probably because of this, and normally people who have seen me chair this is I try and keep it as light as possible, or as try and put a joke in when I can. And this is the first time that I don't think I can. The recent events in the past few months have been yet another chapter in one of the sorriest stories, I think, of our generation of people with Gaza. The relentless horror on our screens and on social media has reached a point where, and I was talking to friends about this once, is we are now in a position that we've almost become dehumanized to seeing people and children die constantly every night and being almost without any remorse on the other side. There are questions later, but I'm afraid...
Not a question, just a comment. Only Muslim children, not other terms. If it was a different thing, everybody will be talking about it.
Can you put the mic a bit
Sure.
shorter?
I meant to be impartial on this, but I'm not infuriously angry. But,
If you close your eyes, you will become impartial.
I appreciate that, but I think it's also...
And your brains.
But actually, what the person on the floor has actually just articulated quite well and exemplified is there are three parts to any kind of cause. There's a mind, a body, and a soul. And all of us portrayed our soul vigorously when we were on the streets and protesting and retweeting and talking about how angry we were. There was also the element of the body of people being watching TV and talking about it and commenting online. But what I always felt that we missed, and what I felt I was lacking, was that incision of analysis and that sense of mind. Whenever you're in an argument, and I get this all the time, you get angry, and you're angry before you're logical, and you start blurting stuff out. You're not rational, and afterwards you're always kicking yourself, saying, I should have said this, and I should have thought about that. You come across it not as powerful as you should be. And that goes back to the idea that I believe in personally, that being aware of the facts and the legal reasons behind things and being logical empowers you to make the case, not just to be angry and not just to be passionate. There's a third part of being cogent. And I think that's what we're going to focus on this evening. And I appreciate all of us have had strong passions about this, and frankly you can tell from me as well, and I probably agree with you, but what I want to focus tonight on is a nice education to really hammer down the points. So when we're faced with opponents and when we're discussing this, we can lay down the law, quite literally, in very cogent, dispassionate points, because I think that's the thing that makes things most powerful. And I've got two great speakers next to me who are going to help us do that. And if I were to define my first guest in one word, I'd call her enviable, because I'm a lawyer and she's a much better one. She's a Fulbright scholar, she's a Harvard Law graduate, and her work experience includes working for the Human Rights Commission, the War Crimes Tribunal for Sierra Leone. She's also a barrister currently, and it turns out we're both from, we both went to the same university in the States. And please welcome Susan Bryant. And from the enviable to the adaptable, and there's a reason why I said that, because I was looking for a word that rhymed with enviable. We have an Eversheds lawyer, which is a city firm, a person who focused on project finance, learning numbers, and learning how to do deals in that transactional world. He then was very successful at that, and then moved on to Savills to work in corporate finance, and then focused on the Middle East. He then took those two skills that he had, which very people do, and then used them for good, and used to develop the Human Rights Legal Aid Fund. He's also a trustee of the City Circle, and a good friend. Ladies and gentlemen, welcome Rashad. I've been informed by my speakers that they need no more than 10 minutes each to speak, because what we want to do is give you as much time as humanly possible to ask the most legalistic questions. And don't be afraid to say, for example, and I don't know what the 1948 resolution means. What are we talking about? Now, that perhaps is a bit more descriptive, but much more about how can we use the resolutions to our advantage. We're going to block this out to speeches, which will be as brief as possible, but as poignant. And please deal with me with the questions, because I'm assuming there's going to be a lot of them. But I'm going to kick off with Susan first. And please, of course, make sure your mobiles are turned off and the fire exits are there, I think. Sorry, no, they're not. They're actually further down. All right. And of course, yeah. And of course, for those who wish to pray longer, we'll probably break straight after the speeches.
Good evening. Thanks so much for coming out. It's always a real pleasure to be here. Last time I spoke, it was on a really warm summer's evening. There were not quite so many people here. So thank you for the not so welcoming weather as well. What I'll try to do is give a bit of context relative to international law. I know you don't need a boring lecture at the end of a long work week. But it's really difficult to talk about international law in the abstract, and I think it's really important to put a little bit of context. Obviously, it's not easy to cover this amount of material in a short period of time, but the idea is to throw out the context which will then spark your questions and your comments and your outrages. So that's the reason for me trying to be brief. That means I'm looking forward to your questions and corrections. Essentially, if you think about the law as you and I experience it day to day, there are really simple illustrations of the law where you understand what the law means, you understand whose job it is to interpret it, you understand whose job it is to enforce it. So if I'm driving here and I get pulled over for speeding, it's very clear to me that the police officer has the right to stop me. If I dispute having been pulled over, and I go to court and I'm in front of a judge, it's equally clear to me that the judge has the right to interpret the law, decide what it means, whether or not I'm right or the police officer is right, look at the evidence. And then at the end of it, when the judge decides for me or against me, it's also clear to me that he has the power to enforce that law. And I can be sent to prison if the offense is such. I can get points added to my license if the offense is such. But that's probably as clear a legal illustration as you'll ever get. On the other end of the spectrum, we have international law. So Rashad and I were talking about this earlier. So who writes international law? Well, it's not always written. That's to start off with, to make things a bit uncomfortable. When it is written, sometimes it's written between countries, so you're talking about conventions or treaties or agreements. Sometimes it's something that emerges over time, a custom or a practice. Let's take, for example, the use of drones, and I'm talking about specifically drones that kill. I would argue, and a lot of other legal scholars would argue, that when you don't have a legal framework that puts out in writing exactly what is and isn't permissible when it comes to the use of drones, the way drones are used customarily starts to become the law itself, strangely. And so when the Americans use drone technology as effectively, brutally effectively as they do, and no one stops them, and no court stops them, that is the nature of international law, that becomes the accepted practice when no one has stood up to it. And that's why when it comes to, for example, arguing for the poignancy of our membership in the European Union, this is a good example of where the European Union can play a really big role in holding the Americans to account. So if, for example, the European Union wanted to say, wait a minute, we don't agree with how drones are being used, we think this is illegal, we think this is disproportionate, and relative to Gaza, I'll talk about proportionality in a lot more detail. If someone spoke up, like a union of states, which the European Union is, and said to the Americans, what you're doing is wrong, then I think that would stand a very good chance of stopping it in its tracks, or at least slowing it down. But the nature of international law is that if no one does that, what happens, what is normally practically accepted, can evolve into what is essentially the law. So following up the example, so how does it get written? Well, sometimes it's written, sometimes it's not written, sometimes it evolves, sometimes it's in treaties between states, sometimes it's in big conventions like the European Convention of Human Rights that countries sign up to. When it comes to how it's interpreted, again, generally judges, but not always judges. Sometimes tribunals decide that, sometimes human rights committees decide that on the European level, on the UN level. I probably won't have to tell you that if you're before the UN Human Rights Committee, the Human Rights Council, they don't have the ability to do anything. They're a political instrument, they're part of the UN. So not like me going to magistrate's court because I've gotten pulled over for speeding. So when it comes to the enforcement of international law, you won't be surprised that's where it gets its weakest, its most complicated, in terms of who would have the power to actually enforce it. In the introduction that we have recorded, but not given you, which is a bit of an odd thing, we've done a video introduction to this talk, and one of the things that was spoken about was a case before the International Court of Justice. A brilliant case that will be spoken about probably in a bit more detail. But the question is how to enforce it. That's a case where one state has gone after tackling a particular difficult legal issue. But how do you enforce that? How do you make sure it's something other than what's just written on a piece of paper? So I say that not to put you off of international law, but just to say that it is very different. And of course the elephant in the room that you'll be very aware of is politics. Because if you don't have an enforcement mechanism that's agreed, so like the police officer, if you don't have someone who's interpreting the law, which is agreed, like the judge, then all of a sudden politics makes a much bigger role for itself. I say that not to discourage you, because of course, as we've already heard from the floor so far, of course there's every reason to be very pessimistic and I would say even realistic about the political limitations of our action. But that, in my view, is where the law has to push back and demand more of politics. And I think all of us have a role to play in that. But with that as kind of the background of talking about international law, let me just lay out a few dimensions of understanding the situation in Gaza. One is we hear bandied about a lot of times war crimes. What exactly does that mean? Relative to Gaza, principally what we were talking about is murder, mistreatment of individuals as a result of a conflict that's ongoing. Another example of a war crime would be the killing of hostages, which you'll know from the latest round. That was one of, certainly not the only, but one of the things that contributed to what followed that couldn't have been anticipated. The other term that we hear spoken about quite a great deal is genocide, and a lot of people again don't know what that means. That is much more defined, much more focused definition than war crimes. There are a number of things that can be considered war crimes. Genocide is when you really have a systematic destruction of all or a really significant part of a group of people, either by race, by ethnicity, by religion, or indeed by national classification. So genocide, if you will, is going to be much more difficult to prove because you have to prove not only that the thing happened, the killing, for example, you have to prove what the intent was, the much broader intent, that it's a systematic attempt to destroy this whole class of people. I'm saying that not to say that I don't think that genocide has taken place somewhere or not. I'm just saying that from a legal perspective, genocide is much more difficult to prove. And so that's not going to form a big part of our discussion today, but just so that you know that. I want to talk about the International Criminal Court, but I will also leave that to your questions because there's been a lot of misunderstanding about what the International Criminal Court can and can't do. And then I want to talk about proportionality because, of course, relative to Gaza, I would say that's the most important thing. It's the most important concept for all of us to understand. And I couldn't agree more that you've got to have the ability to articulate in neutral, calm terms what your side of the argument is, or you have no chance of persuading anyone of a different way of thinking, especially when it comes to Gaza. So essentially, a lot of the discussion, and interestingly, for the first time, the Israeli government was forced to acknowledge they were losing the PR war, was the expression that their spokesman used. For the first time, I think, in recent history, they were completely outmanned. They were, I think, in large part because of social media and the role that it took. There were a lot of people that were able to fight back when the arguments were made about what Hamas was doing, and civilians that were being killed and indeed injured in Israel. The numbers then were, talking about the evidence again, the numbers were then shared. So when you talk about proportionality, though, it's not just a matter of numbers. We all know that the numbers are mismatched. There's no question about that. Proportionality is more than that. Proportionality, in this context, says you have to look at what the objective is, what the military objective is. So of course it would be wrong if Israel, or indeed Hamas, if anyone sets out on a military campaign that's geared towards civilians. Everyone acknowledges that that would be wrong. The question is, you have to weigh what's called the military advantage against what the damage will be to civilians. So let's try to take some desperate examples so that we can see essentially how you get that balancing act. If you're talking about something, an operation that's meant to deal with, for example, let's say for the sake of argument that people were coming out of the tunnels that we've heard so much about, and that Israeli civilians on the other side were very vulnerable, and you had a high concentration, I'm not saying this is the truth, but I'm just saying for the sake of argument, you had a high concentration of weaponry in the tunnels that were facing up to civilian populations on the other side. You could say, if you're Israel, that what you're trying to do is defend what is essentially an imminent attack. And in that way, then the military objective is a very considerable one. Let's take another example. And in that case, if you did have civilian casualties, you would probably be able to justify it, because you would say, look, the military is right upon us. We're doing our best to push back the minimal amount. Again, I'm not saying that that was the case in Gaza, but I'm just trying to come up with a kind of extreme solution that would illustrate that point, that that's where the balance would probably end up. But let's say, and this is not a made-up example, let's say that it's a hospital, or a school, or a UN agency that has been a safe haven chosen by the UN for children. Let's say that, and they always will, that the Israeli government says, well, there's some weaponry in there, in the school, in the hospital, in the UN agency headquarters. Even if you have the allegation that there's some weaponry in a building, if the vast majority of the people in that building are, of course, civilians, I think you're going to have a very difficult time saying that you've struck the right balance. So again, when you talk about proportionality and when you're trying to persuade other people to look at the conflict in Gaza differently, think not just about numbers. The numbers are part of it. But the question is, what's the military advantage trying to be gained, and what's the civilian impact of that military advantage? Okay? Then the last thing I want to talk about, and then I'll be happy to take questions, is the International Criminal Court. Lots of confusion about this. Here's all you need to know about the International Criminal Court. There are essentially three ways that a case gets before the International Criminal Court. You have to know that the International Criminal Court is a permanent court, so it's not going to disappear after a particular conflict. That should give you some comfort. But still, there are only three ways that a case gets before the International Criminal Court. One, the UN Security Council makes a referral. Speaking of politics, I think you can probably figure out what the problem is with the UN Security Council referral. My good friends in America, I think, probably wouldn't let that one go through. And there's a good chance the Russians wouldn't allow it either. So let's, for the sake of argument, take that one off the table. Then there's the possibility that the International Criminal Court prosecutor herself can initiate it. There's a brilliant piece she wrote in The Guardian just last week saying, hey, hold on, I can only prosecute where there's a country that's part of the Rome Statute that agreed to be part of the International Criminal Court. Okay, without getting bored, the Rome Statute is just basically the treaty you sign up to that says you want to be part of the International Criminal Court, both to be prosecuted and to prosecute. You can't sign up for the International Criminal Court and say, I want to go after these people, but I don't want to be subject to it. It doesn't work that way. You're either what she's saying is, hey, as a prosecutor, I prosecute cases, I investigate cases before I decide whether to prosecute them. But I can't deal with the question of whether or not this is a state. I can only engage when there's a state involved. So basically, sort yourselves out. Decide what you are, whether or not you want to be part of the Rome Statute. To make it even fuzzier, Palestine is recognized. So where does that leave us? So we're going to have the Palestinian territories, I don't know, because it does your head in. But the point is that the ball is essentially in the court, not of the prosecutor, of the court. See, you said there was no opportunity for jokes. You're not
still the case.
But essentially that's what she has said. I have no problem investigating, but I have to have clear to me whether it's a state involved, whether or not they want themselves to be part of, subject to the International Criminal Court. Historically, that means 2009, Hamas and its leadership did say, we want to be part of the International Criminal Court, we want to be subject to its jurisdiction. And what she said was, hey, a lot has changed in that particular 5 years. You need to renew your application, essentially, your desire. Of course, the other thing that could happen is that, and that would be, that's considered self-renewal. Referral, not renewal, I don't know what self-renewal is. Self-referral. So the state itself says, I want to be subject to. Now what that means, again, is that you have to be subject to the ICC for good or for bad. They could very well find out that you have committed crimes and you could be charged for those. So the Palestinian Authority has been a bit reluctant, and there's some internal political disagreement about whether or not that's the right way to go. Now, who are the other people that could self-refer? Israel. So if there's anything less likely than a referral from the UN Security Council, it's a referral by the State of Israel. So I wouldn't hold my breath for that. When it comes to the UN Security Council, the one thing that I would bring to your attention in terms of who can put pressure on them, and I think it's really important for each of us to think about how we can put pressure on those who can put pressure on the UN Security Council. The Human Rights Commission does send out these fact-finding groups to go on the ground, to gather evidence, and then to make recommendations. And they have a good track record of doing that quite effectively, and then going back and making reports to the UN Security Council recommending that they make referrals. But in this case, it's really important that we recognize the role that the UK government has to play. And getting back to the comments at the very beginning, it's important that we see that we have a role to play in forcing the UK to put that kind of leverage, that kind of pressure. And when I say that international law is very different than national law, it is and it isn't. Look at the example of the King family and what they went through over the last week after being hounded with a European arrest warrant and facing extradition, held in jail in Spain, separated from their son in hospital. In fact, the whole family separated from the son in hospital. Massive public outcry here in Britain and elsewhere across Europe, saying that that wasn't in the public interest to prosecute and to try to extradite people in a situation like that. And what happened? The prosecution changed their mind. They dropped the case, they withdrew the warrant. I'm not saying it's entirely because of public opinion. I'm saying that politics is always part of the law. The question is, how do you engage in the most positive way? And that I leave to you.
No, thanks to Susan. I'm going to hand over to Rashad in a minute, but after Rashad I think we'll break for Margaret. But before we do, I'm going to be cheeky and ask a question. What's the so say for example we do get Israel in front of the ICC. What's the sanction? They go through the process, they're found guilty, and then what? What could the ICC actually do?
Unlike the ICJ, where it's just state against state,
Civil.
the ICC is individuals. So an individual is in the dock.
Right.
Yeah. So it's not the state of Israel's done this or that. It's this military commander called for that action, which was violating, and as a result, he's now in jail.
So it's not the IDF, it's Benjamin Netanyahu, theoretically, who's
Yeah.
in front of the ICC.
Thank you, Susan. Essentially, the question that I want to focus on and try and answer is a fairly simple one. Anybody who starts to look at international law, and there's international humanitarian law, and then there's international human rights law, and they kind of sort of merge occasionally. So it's a bit of an intellectual and conceptual minefield. And the reason for that is not necessarily one of perhaps intent or design. It's really a simple question of evolution. I think if you look at most evolutionary species, the ones who've been here longer tend to sort of mutate into some form of greater elegance. And I think international law hasn't really been through that metamorphosis. And if you were to actually ask the more philosophical question about intention, and those people who drafted the fundamental principles of what we consider to be, in a modern context, humanitarian law, it's actually a very recent tradition. The greatest body of international humanitarian law comes from essentially the aftermath of any guesses? Second World War. So we're talking, sort of 60, 70, 80 years, 8 decades. And the central articulation where the world basically said to itself, never again, is that we need to create a body of law and principles where it's not just the individual states protecting their own individual citizens, but there's some form of social contract which exists because people realise it's not really individual groups or individuals who are responsible for mass genocide. In reality, it's states themselves who are often the perpetrators, and individuals and people often need to be protected against the state itself. And the articulation of that body of sentiment, which then turned into a form of what I call body politic, which then was articulated and turned into a form of law, is best enshrined in one set of laws, which is summarised in anybody? One set of legislation, one body, which I suppose humanity should really be learning by heart in every kindergarten. Yes?
Declaration of Human Rights.
Absolutely. Okay, so the Universal Declaration of Human Rights is in fact the central, shall we say, pulse from which other international legislation really emanated. And there's international political covenants against torture. There's actually international law in terms of the conduct to regulate, armed conflict. There's regulations in terms of regulating freedom of movement of people, freedom of movement of goods, as well as obviously all the international body of trade agreements, which actually emanate from freedom to basically earn, freedom to essentially follow economic pursuit, and the freedom essentially to live. And another body of law which is more recent, which again takes its roots from the UNHCR, is the freedom of religion, the ability to have freedom to express one's religion. Which is why it's quite interesting when you look at one of the greatest modern crimes in terms of international law and human rights, and that is the conflict that's going on in Palestine and Israel. It's very surprising then that, with the intention of international human rights legislation, with all of these treaties in place, with the Geneva Convention, which essentially was probably the most landmark constitutional framework of implementing the principles of the Universal Declaration of Human Rights, that we have not really seen one single criminal conviction of an occupying force or occupying power, nor have we seen any sort of international statements by international courts, apart from one case, which was with the ICJ. And the ICJ is essentially almost like a civil version of the International Criminal Court, with some big differences between state parties. And that was an advisory opinion, which I think the Security Council mistakenly requested, and were expecting essentially a greater degree of confusion or ambiguity. But actually, I think 14 out of the 15 judges articulated, both in terms of ratio and obiter, some of the most condemning points of clarification about the so-called barrier or the wall dividing Israeli territory, annexing some occupied Palestinian territory, and also actually making comments on framing the discussion around the status of East Jerusalem. So I think it's really that particular case which gives a lot of lawyers one important thing which we didn't have before, and that is hope. That actually one court where there was a referral by the Security Council themselves, if given the opportunity in an objective, non-political, legal context, will actually rule fairly, transparently, and apply internationally accepted principles, which wholeheartedly compensated in terms of, certainly legally, emotionally, the Palestinians in terms of what they're suffering. So that's one particular, shall we say, bit of glimmer or hope that I want to just put out there. The second precedent, which essentially has motivated us considerably, is looking at probably the most analogous case. Lawyers love precedents. Lawyers aren't very creative, so we like to lean on stare decisis, they call it. We like to lean on the past to prove that we're actually making sense. So what is the one conflict, or what is the one case internationally, which is probably almost on sort of all four sort of squares with four legs with the Palestinian struggle? Tibet, that's probably a more nuanced one, but what is the one which was, in terms of global positioning, probably had? Sorry? Ireland. And that's probably two states.
South Africa.
South Africa. So leading question again.
Until it gets
Apologies, Your Honour. In terms of South Africa, well, again, that was never tested, unfortunately. But in terms of courts, in South Africa, one of the things which the South African ANC movement was able to do very effectively is they set up something called the Defence Fund for South Africa against apartheid. And that fund was actually launched in London and raised approximately over £1 million, and was able to galvanise international lawyers and fund them towards the defence of Nelson Mandela and the articulation of a conflict which was being very much confused domestically into an internal insurgence, an internal act of terrorism by a terrorist organisation who were essentially a powerful, successful, democratic government, essentially trying to stop an insurgency from a section of their population who already enjoyed civic rights. So you can already probably hear some of the echoes of the articulation of the PR strategy of Israel, which actually takes its own bedrock from their interpretation of international humanitarian law. It's not surprising why you'll see Mark Regev constantly repeat words like terrorists, and constantly repeat words like defense, and constantly repeat words like we have to protect our civilian population, because there are specific ramifications in terms of international law, in the law of armed conflicts, which suddenly give Israel legitimate power to respond to national security threats. And probably the easiest get-out-of-jail card in terms of modern legislation is the famous word terrorism. because such is the difficulty in terms of pinning down what that actually means. But despite the fact that it's difficult to pin it down, such is the veracity of state sanctions available without following the normal rule of law, the normal principles of awarding to any suspect in any traditional criminal legal process, that that's basically the get out of jail card, both for states like Israel and often states, even our own state and our own government, in their attempts to basically deal with the scourge of terrorism. I'll simply end at this point by giving you a sort of a practicalization of that sentiment. And that was when we established HRDF, which was, again, really trying to essentially copy the precedent of the South African Legal Aid Fund and overcome some of the, what I would call, structural impediments to justice, which are faced by the Palestinian people. And let me set out quite clearly what they are. Now, if you're a Palestinian and you're a Palestinian family, and your home, your apartment block, your business, your hospital, your gas power station has just been bombed by your neighbours. Now, the obvious thing that we would do, sitting in London, Birmingham, any sort of civilized jurisdiction, is would be making calls. After we've called the ambulance, after we've called doctors, after we've essentially bandaged wounds and essentially dealt with the initial emergency relief. The natural instinct following that for any human being is to obviously have that crime or have that grievance dealt with, and dealt with by legal means. However, again, put yourself into the situation of that Palestinian family. Which lawyer are you going to call in Palestine? Even if you call a lawyer in Palestine, what legal infrastructure exists, both in Gaza or in Ramallah, in terms of the PNA, which can offer any form of recourse? Because the perpetrator, or the alleged perpetrator, to be legally correct, is not under the jurisdiction of either Gazan government authority, and Hamas is the de facto government authority, despite its prescription by foreign forces. It still remains the legal government authority of that people. In Ramallah, you have another state authority, state inverted commas, which more or less practices a form of an extension of the security apparatus of the occupying power. So if you have an occupying power which controls all of the exits, which controls the airspace, which controls the seaport, then if you were to basically create a government authority, it can only essentially function as an extension of the state security apparatus that's surrounding you. So again, even if you were to launch a case in Palestine, it would have no effect. The next thing is to basically try and launch a case in Israel. And again, I'm sure you won't be surprised that of all the hundreds and thousands of cases of stolen property, of settlement building on land which has been seized, of farmland which has been occupied and seized, of the thousands of cases of existing civilian Palestinians living in Israel as citizens, they don't actually make it often past the first hurdle, let alone the idea of a Gaza who's actually physically not part of the legal infrastructure of Israel utilizing those mechanisms. Hence, it was essential to basically create an international legal fund outside the space of the theatre of the conflict. And by doing that, the second challenge is lawyers, despite their perhaps initial motivation in terms of choosing law or the practice of law post-A-level, are commercial creatures. They essentially, like anybody else, have a specialist skill. And some of the best minds and the best legal minds, etc., they essentially come at a cost. Whether it's pro bono or whether it's sort of discounted on the basis of a humanitarian cause, you can cannot take on a case where the defendant is the state of Israel, or essentially bodies associated in the Israeli project, such as settlement builders, construction companies, people like G4S, building prisons, etc., in the occupied territories. You cannot take on this opposition unless you're tanked up yourself, unless you've got legal ammunition, unless you can fund teams of experts to go in and collect the primary evidence. I mean, so it's almost like ambulance chasing. But, one of the most important things, as criminal lawyers I'm sure will testify, after the scene of a crime, is to secure the crime scene, is to collect the evidence while it's fresh, to get experts, ballistics, experts, to get medical experts, to get testimonies from credible people. So it's very interesting that one of the first things that Israel did straight after this particular operation is to prevent human rights observers like Amnesty and HRW from actually accessing. So again, that's another formidable task of the Legal Aid Fund, is how do you get money and financing and expertise into the zone of conflict in the shortest possible period of time in order to collect that evidence. I'm going to illustrate the work with one live example, so hopefully you'll get a good flavour of essentially what we are up against, but also what the art of the possible is. After Operation Cast Lead, which was equally, if not, I suppose, overtaken by the tragedy of so-called, I even forget, it just doesn't make sense. Protective edge. I struggle for those words to describe what's happened. But the first thing was essentially to try and get the evidence encapsulated into witness statements and documentation. So the first thing was we raised funds, if you remember, at City Circle. We raised £15,000 to basically sponsor the first sort of set of legal aid. We got lawyers from Hickman and Rose, a very respectable, human rights law firm, Danny Macover and his team, to fly into Gaza. We then leveraged our contacts within the Egyptian government, who was obviously very different at the time in terms of their policy towards Gaza. Having funded them and experts, sort of medical and military experts, to go in the process of collecting evidence by partnering with a local NGO. So Mizan and Al-Haq, who actually do fantastic human rights work on the ground and actually face bullets and bombs as compared to human rights lawyers sitting at distance, will actually physically go in and meet the families and actually find, you need a victim, essentially, to launch a legal case. And so they found a number of victims, which I'm sure was not very difficult. Then one has to persuade the victim that, look, are you prepared to go to court and actually, seek legal redress when there's a big risk that an F-16 will actually bomb your house next week because you present a risk. So that process then required us to essentially white label the victims into the NGO. So we lost a lot of legal potential, even UK legal aid possibility, because we couldn't use the name of the victims. So we had to use the NGO as the plaintiff, essentially. So having collected all of that evidence, having collected essentially, real cases, one family where 1-ton bomb had gone off allegedly to kill a Hamas operative, and the entire Al-Matar family, 16 members of the family, had been wiped out in a 3-story house. That particular case we then took and analysed from a strategic value point of view. There's no point at that point trying to take Israel to a war crimes tribunal because one doesn't exist. Palestinians haven't signed the Rome Treaty, so we couldn't essentially elect to bring a case forward. We couldn't take the case to an Israeli court because we'd be wasting money and guaranteed in terms of losing. So we looked at an alternative legal angle, which was essentially our own government. We looked at the fact that the British government, the American government, Europe, have an arms trade which supply, year on year, billions of dollars, billions of pounds of military ammunition, bullets, prop blades, and we were able to basically link the attack on Gaza from our military expert analysis to specific British companies who, in the chain of causation, one could demonstrate were actually helping to supply arms to what was potentially a war crime. So actually companies which supply and assist are under human rights legislation and the Human Rights Act and the European legislation under positive duties of care, as are governments who signed up to these international treaties, to verify that whether such support could be potentially used for war crimes. And if that risk is there, one must simply prevent the issuance of licenses, must prevent that crime from taking place. Interestingly, the British government had licensed a whole series of British companies, which made it very easy for us to actually challenge directly the Ministers of State, Miliband, and Mandelson, who were responsible in terms of British trade for licensing these companies. And that was the first case, which then went all the way to the High Court. It was absolutely fascinating that for a mere sum of £35,000, one could actually take our government to court and make them accountable towards such a clear violation of international law. And the sort of signals that gives back to Israel, an ally, was absolutely considerable. Without going into the minutiae of the challenges of the legal case and the prospects of its success, one key issue that came out of it was there was a Whitehall review of all existing licensing. A new whitewash procedure was agreed within government and documented in order to basically ensure future compliance by the British government in terms of best practice during the term of the Labour government. Now, interestingly, because that was done, and it's partly inspired and funded by small donations by people like yourselves from City Circle, other people who got involved. That then has now created a precedent following this current invasion, this current operation, where the British government can be clearly held accountable for what it's done since that time and now, when they were clearly on notice by the court, where they've been reminded over dicta in the case of Al-Haq versus the State Departments of their responsibilities under international law. That reminder is not a ratio of the case, but it's certainly obiter. So that presents a lot more in the way of opportunity. Another big area of advocacy or lobbying in terms of political pressure then resulted us being able to look at issuing arrest warrants. And again, to a very small program of funding, it is very, at that time, pre-Attorney General discretion. One was able to actually get the evidence from this family, from Gaza, go to a local magistrate's court in Britain, successfully convince the magistrate there was sufficiency of evidence that a potential war crime had been committed, identify a specific person, and the person that we identified was none other than Libby Zibny, who had command and control of operation. And she was essentially targeted for a potential arrest under the rules of universal jurisdiction. Now, you probably won't be surprised, because you probably saw it in the press, that as soon as she landed, the plane was turned around and, she took off again. So, British government complicity in terms of intelligence serving prevented the rule of law and justice from actually being actioned. But, this is just the start of the art of the possible. And, this has been done with literally a shoestring budget, with very brave sets of lawyers like Gareth Pearce, like Michael Mansfield, like Tayyip Ali, like Susan, who are ready to come forward and work more or less for free, just covering costs, to get the right sort of expertise around them in terms of expert witnesses. But in terms of opportunities for legal actions, I can probably sit here and list another 10 actions that we've actually started but haven't quite publicised for strategic reasons. So the possibility of, in my opinion, moving this conflict from its current discourse and terminology, which is highly emotive, which is, you started it, no, you started it, we got there, whose land was it? Very emotive, non-legal arguments. Well, you fired the first rocket, well, you kidnapped those kids, etc., etc. To move it from that sort of, almost playground sort of tit for tat, which is lost in the media, and in terms of sound bites, it's really all about, spin. Moving that away from that context, and also, again, looking critically, internally, at our own Muslim, scene, where the conflict is purely described in terms of a narrative, a binary narrative, to quote one of my friends, of an us and them, of Muslims versus Jews, two faith groups at loggerheads, terminologies about, a jihadic sort of narrative or response. One can talk about the right to defense. One can talk about Geneva Convention. One doesn't necessarily have to become, flower power. The law recognizes the legal right to resistance. It's actually enshrined in the Geneva Convention. But until we start embracing, as Muslims as well, and in our own understanding of Sharia law, where you've got the maqasid of Sharia. The maqasid of Sharia, and if you compare the objectives of Sharia, anybody who studies it, and I encourage anyone to study the maqasid of Sharia, and you compare the list under the objectives of Sharia, and you then read a copy of the Universal Declaration of Human Rights, you will be shocked at the degree of synergy. So I'm, advocating, and so in Sixth Circle is very much advocating a move away from essentially this stalemate of simply protesting, and I think protests are absolutely great, but simply politically protesting, simply marching, simply funding humanitarian missions in terms of medical, etc. I say do that, but on top of that, legal advocacy, access to justice as a principle of human rights, legal access to justice as a mechanism for actually breaking the deadlock. In my opinion, I don't think the Israeli war machine is really worried about Muslim charities or international human rights charities. They're not worried about people rebuilding Gaza for them because they've just essentially demolished it and getting the European Union to pay for it. What they are worried about, and it's not just PR, what they are worried about is that when they get on the plane and they basically fly to New York, or they want to go and shop at Harrods, or they want to go to Paris and the Champs-Elysees, that somebody doesn't tap them on the shoulder and put a pair of handcuffs on. Now that is something which every Israeli citizen, military or political, is incredibly nervous about. And secondly, it just takes one or two breakthroughs where one of these cases ends up in the right court, such as the ICC. And we pray and we exhort and we hope to lobby to pressure the Palestinians to be essentially fair to their own people without hesitation. There's no strategic value in hesitating in terms of not signing with the ICC. So we really, just to conclude, there is tremendous potential, tremendous hope, but it takes a mobilization of resources, financial and people power to give the Palestinians their day in court. Thank you.